Okay. Yeah, that's fine. Okay. So first of all, I would like to thank Stuart for this very interesting symposium and for this really kind invitation, which gave me the opportunity to present a point of view from a lawyer and the question of illegal cyber operations and the concept of positive obligations of states. Yes, good. The increase of cyber operations targeting administrations, economics and vital infrastructure is widely seen as one of the most pressing and potentially dangerous threats for national and international security. These hostile cyber operations often take place using computers of non-state actors located in foreign states. This situation raises the question of these obligation of these third foreign states to prevent, notify, and react to these operations. Indeed, the general principle of international law of due diligence obliges states to protect foreign states and their citizens against illegal acts committed on their territories or under their jurisdiction or control by non-state actors. However, the determination of the scope and the applicability of this due diligence obligation to cyber terrorism or cyber security is not an easy one. In this field, the international protection of human rights gives us some very interesting insight, especially with the development of the so-called positive obligations of states. Indeed, the international protection of human rights involves not only duties of abstentions from states, but also obligations to act in order to prevent and to sanction any violations of human rights by non-state actors. So the objective of this paper is to evaluate, presenting 5 points, what could be the relevance of this old principle of due diligence in relation with cyber terrorism in the light of positive obligations of states. So let's turn to the first point. As it is well known, due diligence is derived from the principle of sovereignty of states. Since the island of Palma's arbitration, duty of diligence was reaffirmed and developed in many cases. Among them, the most famous one is undoubtedly the Corfu Channel case, in which the ICJ, the International Court of Justice, said that every state has the obligation not to allow knowingly its territory to be used for acts contrary to the rights of other states. Today, it is largely accepted that the dictum of the court expresses a general principle of international law. It is also accepted that first, the duty of diligence is an obligation of conduct and not of result, as it was said by the ICJ in the genocide case in 2007. And second, that the principle goes beyond the territory of states and covers all activities which take place under the jurisdiction or controls of states, including, of course, cyber activities, whether these activities are launched from the territory of a state or just routed by the territory of a state. Indeed, there is no reason to consider that transit states do not have a duty of diligence. If a state knows, for example, that a terrorist group is about to cross its territory to attack a third state, the duty to act and to prevent exists. And the same applies in principle to illegal cyber attacks. This being said, we should not underestimate the extraordinary challenges created by the nature of the operations and a messy cyberspace. In several cases, it would be impossible to prove that there was knowledge of this act in the transit state. And even if such knowledge exists, with regard to the rapidity of transit in cyberspace, it is therefore unlikely that any state of transit could be held accountable for violating the due diligence principle. On the other hand, if a cyber attack is launched using public or private computers located in the transit state, and the latter had or ought to have had this knowledge, things could be different. So, as we all understand, knowledge is a decisive element. So, let's turn to the second point. In the hostage case, the ICJ engaged Iran responsibility after concluding that the Iranian authorities were fully aware of the urgent need for action on their part. Nonetheless, states can't have absolute knowledge of all things happening on their territory. This is why in Corfu, the ICJ stated that it can be concluded from the mere fact of the control exercised by a state over its territory that that state knew or ought to have known what was happening. And in a similar way, the European Court of Human Rights said in the Osman case that such an obligation must be interpreted in a way which does not impose an impossible or disproportionate burden on the authorities. Then the question is, what will be the standard of proof in order to show that a state knew that cyber operations were taking place on its territory? This proof could become, in many cases, a real probatio diabolica. Indeed, the victim could be unable to furnish direct proof of facts to demonstrate the existence of such knowledge by a foreign state. This is why, in order to avoid this, the ICJ said in Corfu again that proof could be facilitated for victims. But a second problem is even trickier. Does cyber diligence apply only in cases where states have actual knowledge, or should it also be applicable in cases of constructive knowledge, when states ought to have known the situation? Here again, the case law of the ICJ and of the human rights bodies are extremely useful. In Corfu, the court said that a state on whose territory an act contrary to international law has occurred may be called upon to give an explanation and can't evade such a request by limiting itself to a reply that it is ignorant of the circumstances of the act and of its authors. And in a similar way, the European Court of Human Rights and all human rights treaty bodies constantly accept the idea of constructive knowledge in relation with due diligence and positive obligations of states. But does due diligence then imply an obligation for states to monitor cyber activities on their territory? The answer should be positive because, as it will be seen later, due diligence implies not only an obligation to react, but also to prevent. Vigilance and monitoring are thus going hand in hand. In the pulp mills case, for example, the ICJ held that due diligence implied the exercise of administrative control applicable to public and private operators, such as the monitoring of activities undertaken by such operators. And the recent French book, White Book on Defense, also presents monitoring as a cornerstone in the fight against illegal cyber activities. But what a slippery slope! Could due diligence become a kind of Trojan horse in order to erode civil liberties, starting with the right to privacy and the respect of correspondence? Electric surveillance programs such as PRISM have given rise to heated debate. In this context, it should be recalled nonetheless that the duty of diligence can only authorize acts compatible with international law. The ICJ warned in the genocide case that it is clear that every state may only act within the limits permitted by international law. And also, the European Court of Human Rights and other human rights treaty bodies also constantly emphasize that states must exercise their powers to control and prevent crime in a manner which fully respects the due process and other guarantees. It is thus clear that the criterion of knowledge can't legitimize violations of international human rights or other rules. Cyber diligence should not lead to a kind of cyber hell for freedom. This question of monitoring is also directly linked to the more general question of the duty for states to prevent an act contrary to the right of other states. So let's turn now to the third point, cyber diligence as an obligation of prevention. In Corfu, the ICJ concluded that nothing was attempted by the Albanian authorities to prevent the disaster. And about 60 years later, in the DRC case, the ICJ held Uganda responsible for any lack of vigilance in preventing violations of human rights. But what kind of measures of prevention do states need to take? With the development of positive obligations of states, the international protection of human rights gives us some very interesting insight in this field. Indeed, the European Court of Human Rights and several other treaty bodies expressed the idea that if a state knew or ought to have known the situation and failed to exercise due diligence to prevent, there is a violation of international law. But all these bodies accept also that this duty to act and prevent should not create an impossible burden on the authorities. Thus, they all focus on the criterion of reasonableness, which is decisive here. In this context, a very interesting question is to know if the duty to prevent includes a duty to enact legislation and domestic normative measures. Several human treaties bodies insist on the existence of an obligation to adopt laws for the effective protection of the rights and freedom, and consequently the responsibility of states has often been engaged by human rights treaty bodies for failure to adopt necessary legislative measures. As a matter of fact, it goes without saying that enacting legislative measures in order to prevent and punish cyber terrorism against the right of other states is one of the best ways to implement the due diligence obligation. Measures of prevention of cyber attacks would require almost inevitably such legislative measures. But I recall you that since due diligence is an obligation of conduct, states have the choice of the best measures depending on the circumstances. We maybe find here one of the limits of the due diligence principle in relation with cyber terrorism. If we want to upgrade states' obligation in relation to cyber diligence in order to impose them specific and detailed obligations, the adoption of an international treaty would probably be necessary. One of the best examples is, of course, the Convention on Cybercrime adopted under the Council of Europe. So let's turn now to the fourth point. An obligation to protect cyber infrastructure. Indeed, a related question is whether the state has an obligation to protect its cyber infrastructure against any terrorist use or misuse. According to the US International Strategy for Cyberspace, cybersecurity due diligence implies that states should recognize and act on their responsibility to protect information infrastructure and secure national systems from damage or misuse. And in the same vein, the French White Book on Defense focused on the need of securing vital infrastructure, both public and private. But whatever the interest of these positions, the question is to know whether due diligence includes such an obligation. An answer to this question would be similar to the one given for the adoption of legislation. Due diligence requires states taking all appropriate measures in order to avoid cyber terrorist attack. If a state totally failed to secure its own cyber infrastructure, failure which enabled terrorist groups to use this infrastructure as a weapon, the responsibility of the state could be engaged. This leads us to a last series of questions concerning the obligation to react. It seems well established that under the due diligence principle, states have an obligation to notify and warn the potential victim of cyber attacks. This obligation to notify has been clearly stated, for example, by the ICJ in the Corfu Channel case. But this obligation to react is not just an obligation to notify. As the Tallinn Manual has rightly recognized, in case of injury to another state, the state will be obliged to use all means at its disposal to terminate the activity. If this obligation is not controversial in itself, its implementation could raise some questions. Indeed, in order to stop a cyber attack, states can use different tools that have, in some cases, more or less serious negative effects on third countries and populations. Obviously, in this field, there is an obligation for states to assess the necessity of their reaction and its proportionality. Moreover, states have an obligation to investigate and punish the authors of such acts. Once again, the ICJ in the Corfu Channel case condemned Albania because Albania didn't inquire into the event nor proceed to judicial investigation incumbent in such a case on their sovereign territory. So, as a conclusion, I would like to say that, as highlighted by the notion of positive obligations, due diligence is not only an obligation to terminate a cyber terrorist attack. It is also an obligation of knowledge, of prevention, of notification, and of punishment. But this does not mean that this obligation is of high intensity. Its nature as an obligation of conduct and not of result, based on the criterion of reasonableness, means that states do not carry a burden which is too heavy, especially in the context of cyber terrorism. The cyber diligence principle, thus, is certainly a useful starting point in order to react against states that could be tempted to leave their territory as a kind of cyber haven for cyber terrorists. But if we want now to upgrade this cyber diligence obligation and to make it more precise, one should think about the idea of adopting a universal instrument on cybersecurity. Thank you very much for your attention.